Abusia, breaking news. Ababe coming sa sesia and say Chairman Wontumi akonta man ne ho nsensem abusia ekopie mu e high court Emma high court for judgment date no ehye ende 20th July ya na chese ye ende ya ende Monday e na chese ye the judgment ni eden eba na ende Chairman Wontumi ya sentence no 20 years a chese abusia eya rehosem e de ama the New Patriotic Party members ene Chairman Wontumi na busuafo na ende lawyer Martin Kpebu ababedi nkomo acheche ensem bi mu achesa busuan enye fa dia bro na said ye me magia tum se di ekoso e wo politics mu ne de me kwa kohwehwe na me de aba be so na won so what de den ekoso enti meso send your first time na wa subscribe e de ama me said any update bia nso etomu a onso obenya bi atie enti abusuan ma me fa enwura mu e wo Chairman Wontumi ne ho sensem abusuan akoso e wo media ezu over 1 year kramponie e chese obia expect say Chairman Wontumi ye be sentence no na chese ono so akwa serve aban e ba galamse ho sensem abusuan ye de ball na enye fedi agro no ende pam no twa no finally ya sentence no abusuan be ka mensa na ensem we no obia akire na adwene obia nso aka ensem yewramu na yenkotie hawa
update that we have for you. Chairman Wontumi sentenced to 20 years in prison, and so that is what we can update us on in respect of that particular one. So the breaking news this hour is that the NPP's Chairman Wontumi, Ashanti Regional Chairman of the New Patriotic Party and the founder and CEO of Akonta Mining, has been found guilty for various mining offense. He's been slapped with a jail time of 20 years in prison with a fine that if you do the computation, you are looking at somewhere in the region of almost 300,000 cities, basically. 300,000 cities, basically. We'll be providing a bit more updates and crossover to the court and give you the very latest. With that, Roland will cross over very shortly to give you a sense of what is playing out outside the courtroom. But this is the latest that is coming from inside the courtroom at this point in time. And then within context, we had said that the range that the judge was working with was 15 to 25 years. And so the judge settled on 20 in that particular instance. Okay. And the amount, the judge had a range of 120,000 cities to 180,000 cities. And because there are different offenses, for one, she opted for 120,000 cities. Again, in between, then 180,000 also for another as well. And so very shortly, we'll cross over to the court and give you the very latest. But if you're just joining us, we know that at least Chairman Wontumi, as things stands now, has a jail term hanging around his neck of at least 20 years. We'll get a bit more clarification when Lord Edwasari joins us from the court premises.
All right. So we're having extensive coverage. Lord Edwasari is the one giving us the bit part, but more importantly, the information from the courtroom. Outside the courthouse itself, at the precinct, is our own person, Sixtus Don Ulo, also broadcaster, legal practitioner as well. We've stationed all our men to make sure that we bring you an extensive coverage just beginning after the hour of 10 up till now. We have our man in the Ashanti region monitoring, because Ashanti region is the hub of the MPP, for which we have Chairman Wontumi, Bernard Nkwiboesiakon, as the chair for the opposition MPP, for which there are many interested stakeholders from his party as well as the other political parties, and then the generality of the society there. But more importantly, we also here in Accra bringing you the extensive, what the various sentencing regime is, as we have in Section 99(2) as amended for the Minerals and Minings Act, and then bringing to you what the upper limit and then the minimum of the sentence as well as the fine will be. And Joseph has brought to you what the decision of the court is. But either Lord Edwasari will be bringing to us the latest, or Sixtus Don Ulo. And Sixtus, what can you tell us? Now we know that at least for 20 years, if the appeal per what is accruing to him as a convicted person will be, then it also means that will be a long way. What so far can you monitor outside? the court premises?
Well, before we come to that, I would want to engage Lord Edu-Asare, my colleague who was seated right in the court, and then we can go through that again. But as you can see at the background, you see that there's a lot of movement, media persons here, everybody trying to get the first bite. We are waiting for who has a voice to speak to us to step out. Once they step out, you would hear from them firsthand some of the things that are happening. And even in terms of appeal, I don't think, speaking with a legal mind, I don't think this is a judgment and a sentence that would be taken lying down by lawyers of Chairman Wontumi. Indeed, we got that inkling when they started pleading for a reduction in the sentence. That is what the lawyers call mitigation. After the sentence has been pronounced, you would have some sort of attempt from the lawyers to try to reduce the sentence for the convicted person. They are not disputing the conviction at this moment. At this moment, they are saying that, look, you have convicted our client. We don't have a problem with it yet, but kindly see to a reduction in the sentence. That is the exercise that happened after the conviction. And whilst that was happening, in fact, the demeanor on the look of the lawyer attached here was somewhat anger and curiosity, not so happy. Lord Edu-Asare, how exactly do you describe that?
So, Sixtus, let me just give a bit of a throwback. You recall that the lawyer attached, he filed some motion indicating that he was going to travel, and as a result, he wouldn't be present. And so he sent 3 or 4 junior lawyers to come and represent them, and they made a mitigating plea. They made a mitigating plea for the sentence to be reduced.
All right. Let me cut in that. We have a leading voice of the NPP, but I'm not sure that he wants to grant us any interviews. We have he's swamped, and he actually is not in the mood to grant us that interview. So we will get back to discussing, law attachment, what happened in court.
Yes, so 4 junior lawyers were sent by lawyer attachment because he had sent a letter Friday that he was pleading for a deferment of the judgment against Chairman Wontumi. So essentially, the lawyers who were present, they seemed very uncomfortable with what was going on when they attempted to use that motion for the case to be tried, especially the Supreme Court's
application.
Indeed, we have gathered that he's to the jurisdiction, and for which reason he wrote the letter for an adjournment. He indicated that he'll be back within the jurisdiction on Wednesday, and so
Again, we're coming to you live from the courthouse right here in Accra. And certainly that's where we broke the news live here on TV3, 3FM, as well as across our subsidiaries and across social media platforms where we're streaming live. Chairman Kpebu, an accused and subsequently convicted in this case for a number of offenses in relation to mining activities.
He's been sentenced to 20 years in hard labor with a penalty unit of 10,000 for the 2 counts that he has been charged with. Let me just quickly run you through the charges, which were...
I listened to the judge for at least 1 hour. I was in there for more than 1 hour, but I had to go do my other cases. What I heard was very sound. Kudos to Justice Kokuvite. I'm sure she'll be one of the next candidates to go to the Court of Appeal. She's been in the High Court for long. So we hope President Mama will look favorably on her and send her to the Court of Appeal. She's done a good job. Look, it takes bravery, eh? It takes a lot of bravery to render this decision. We don't, so we should, look at what can be done to also show the judge appreciation. Not everybody can give such a decision, because when you go, sitting in court there and say, hey, is that the Ashanti regional minister? Listen, you see, I'm even saying minister. You see, Chairman Wontumi, at a point, they were calling him what? He said he was the governor. Though there was a minister, he said he was the Ashanti governor. And you know what that meant. You see, so on the ground, he wielded a lot of power. And yet here, today, he was in the dock, and Justice Audrey Kokuvite was reading the judgment. Then I felt that, oh yes, Ghana is working again. Ghana is working again, because this is the same kind of case that where under Akufo-Addo administration, we presented our petitions against Chairman Wontumi as far back as October 2022. 2022, more than 2 years before Akufo-Addo left office. Yeah, right. The CID boss at that time, and Kofi, and then IGP, they were doing kukwasa, like, so to wait, delay, because of Chairman Wontumi's influence. So you see why we had to change the MPP so that the system would work. Because as long as MPP remained in power, Chairman Wontumi was not going to be brought to book. Because he was governor of the Ashanti region, governor. And today he's been showing his real size, right? Yeah, so it's good. It's a good judgment by all standards. By knowing the legal system, you can expect that he's going to go on appeal, etc.
Absolutely. What do you say to those who think that the judge, Kokuvite, should have waited for the Supreme Court interpretation that Samuel Atachian was seeking, or on the minerals aspect of the Minerals Act that was being used in this case?
Well, that would have taken the case too long. It would have taken too long. We don't know when the Supreme Court will do the interpretation. So that was way too long. Even the first question is, as to whether the Supreme Court would even accept to do the interpretation, nobody can tell. You see, when you do a reference, what Atachian's request is that send it to the Supreme Court that this and this and this require interpretation. Now, as to whether the Supreme Court will agree, we will not even know. So it's not something like Justice Kokuvite could take it to the Supreme Court, let's say a week. And don't forget, 31st of July, next week, Friday. That's our last day. We are going on vacation. So from 1st August to about 10th October, these kind of cases, the type that involve giving judgment in criminal cases, people giving evidence, Supreme Court sitting, cannot happen. So the Supreme Court doesn't sit from 1st August to at that time in October. As I said, let's just say practically by somewhere around 10th October, the Supreme Court would not work. Remember that even the year we're clamoring that the Supreme Court should work during the vacation to take care of this Daniel Yao Domlevo case, where we thought that Akufo-Addo had sacked him because they didn't want Domlevo to catch them stealing. Even that one, the Supreme Court didn't sit. The Supreme Court didn't sit.
Right.
Much less at this one. So what I'm saying is that the timelines simply didn't favor Atachian's request. The timelines didn't favor. In any event, and the judge also said that she has done her own interpretations. So what will happen is that now that the decision has been rendered, by all means, they will disagree. So they can file an appeal, and then they can file for appeal, pending for bail. They can also file for bail. They can
right.
be admitted to
so
bail.
Martin, what I'm trying to understand is, I mean, a number of times we've heard that, you know, the wheels of justice grind slowly, and I hear you make the case on timing and the fact that the Supreme Court's interpretation could take a really long time. What would we rather have? That we have this done well and done right, or we rush in getting to a decision as we, as it may be, it may not be the case, which is why I'm asking, right? Was it a legally correct step that the judge had taken in this case? Yes,
on the facts of this case, yes. So I'm very mindful of that policy. Yes, even the courts also adhere to it. That's why justice grinds slowly. That we would rather take our time and do it right than to rush and to abuse somebody's human rights, etc. Yes, that's not lost on the court. And almost every lawyer who means well for this country, we invoke it all the time. But on the facts of this case, I don't think much injustice has been done. You see, when you listen to the judgment, the evidence so far, Wontumi doesn't deny, right? It doesn't deny that he gave the land. But he is saying he gave the land as a concession to Henry Okum and JC Apia to do reclamation. So let's go to the facts. So in order to determine whether there is danger of abuse to his rights, you look at what really happened. What really happened is that the forest has been degraded, forest destroyed in mining operations. And what's the response? Then Wontumi says, oh, I only gave it to him to do reclamation. But the person you gave it to says, no, I did mining on it. Mining. So the one who was in the center of it, the one who undertook the illegal mining, is saying that no, you gave it to me to do mining. So it's mining I've done and destroyed the forest. And Wontumi said, no, I only asked you to come and cover up. That's do reclamation. But you know where Wontumi's case falls apart, as shown in the analysis of Justice Kokuvite.
Very well. And just a quick tracking back of what we have discussed already. I've just been told that there is no case yet at the Supreme Court. Rather, Samuel Atachia, who's counsel for Chairman Wontumi, had indicated an interest to do so, or a desire to do so. So Martin, I guess that we are back to the point that indeed it was a sound legal decision that was taken, and no legal misstep had been taken in this process at all. But looking ahead, you've talked about how there could be other options for them post this decision. What could be there for Chairman Wontumi after this decision?
Good. Now let's correct. Maybe the way the person didn't hear well. So let's correct what's happening. Atachia brought an application, to the court that there is Justice Kokuvite should send the matter to the Supreme Court, Senate. Nobody has said that there's a matter before the Supreme Court. So let's say maybe the person didn't hear well or he doesn't understand.
Oh,
so
that was not for you. That was for me. Because I had asked the question on the premise that the matter was already at the Supreme Court. So I was running it back to correct my question.
But I didn't answer it on the basis that the question, the case was in the Supreme Court. No, the motion is before the judge in the High Court. So he is requesting the judge. And the judge has to look and see whether, in actual fact, it should be sent. So Justice Kokuvite, in reading through, dismissed it. I said, no, I'm not sending it. The matters you've raised, I'm not sending it. So then I was also asking that even when it's sent, it takes a long time. They don't deal with that immediately. So we're just further explaining. Okay. Yes. So now to your new question. Yeah.
Right. So I'm asking, what are the options now, post the sentencing?
Yeah. So a notice of appeal, and then he will be asking for bail pending appeal. Yes, the laws allow it. And that's why earlier on I said if you can demonstrate that the judge got it very wrong, then that is where he can get bail. But if he doesn't demonstrate that, he will continue to serve the sentence. Another option, which I see may well help him and which will support some time in the future, is when he asks for a rate, not in JM's administration, the next NDC administration, because 20 years by our laws, when they give you any term of imprisonment, generally, I'm doing the general rule so that there's no time for the exceptions. The general rule, you serve 2/3. So in this case, you do 20 divided by 3, and then you throw away 1/3. The remaining 2/3 is what you serve. So in this case, if you're doing 20 divided by 3, I think somewhere it will be 6 point something. Now, so you throw away one of the 6. So now he'll be doing a little above 13 years. So
Right.
above 13 years, that's what he should serve. Now, out of this 13 is still very long. So I support a case where maybe by 7 years, if it's any time between 5 and 7 years, if it's granted a pardon with the extra request that he should properly reclaim, apart from the penalty the judge has imposed, if you make available money for this proper reclamation, yes, between 5 and 7 years, if he's this granted a pardon, it's fine. It's fine.
And over this period, we